Good morning, Mr. Noriega. I see you here. Good morning. And Mr. Torres, I see you here. Excellent. All right. Just to remind you both gentlemen, 20 minutes aside. I do have my little timer that I use. I use the iPhone timer. So Mr. Noriega, you have up to 5 minutes for your rebuttal. How much time do you wish to reserve?
Yes, Your Honor, I would like to reserve the full 5 minutes, please.
Very good. And when excellent, Mr. Torrens, you muted yourself. Wonderful. You may proceed, Mr. Noriega.
Good morning. May it please the court. This appeal stems from an order granting a motion for relief under Rule 1.540B. This is a mortgage foreclosure action, as I said, and to give the court a brief timeline, because I think it's important to understand the events leading up to this order that is the focus of the appeal. This action was filed back on August 22nd, 2018. It's a one-count foreclosure complaint that named the appellee as one of the defendants. On September 21st, 2018, the appellee was personally served with process. Thereafter, on December 15th, 2018, a motion for clerical default was filed. A week later, December 21st, 2018, the default was entered by the clerk. Both of these documents on the certificates of service have the appellee listed in the mailing address in which he was served.
Counsel, I think you can probably rest assured that we're familiar with the timeline. Let's kind of jump into the meat of this.
Sure.
As I understand it, back in September, at the time of the service of process, Mr. Wiggs was talking with the lender about a mitigation package and trying to work something out. Apparently, he was aware that he was behind, and this is a VA loan. Is that right?
That's correct, Your Honor. And
so he says that when he was served with a lawsuit, he assumed it had something to do with the mitigation package, which, as I understand it, he actually retained an entity to help him fill that out and send it in, and is still waiting, or at the time this case was briefed, was waiting for the results of that process. Is that what happened?
According to the affidavit, that's correct, Your Honor. It appears that the appellee was in communication with the servicer, had hired a third party to assist him with loss mitigation efforts.
And then he paid, I think it said, according to the record, $3,600 for this outfit to help him, and he assumed they were taking care of it.
That's per the affidavit, yes, Your Honor.
Okay. And from your side, you're looking at the fact that the lawsuit was filed in September. Motion for summary judgment was in March, motion granted in June. And so you're saying an awful lot of time went by that he didn't really participate in this, and it stretches the imagination to think that he was not aware of this throughout those months.
That's one of the arguments, Your Honor, is the due diligence aspect of the three prongs, is the amount of time that went by. But I think even before getting to the due diligence aspect, the excusable neglect portion, which I think forms the foundation of the basis for the 1.540B motion. According to the affidavit, the appellant stated that he was in loss mitigation talks, and when he was served with process, he assumed those documents to be part of the loss mitigation package. And for that reason, he didn't think that he was being sued. But if the court takes a second to really think about what happens when you're served with process in combination with these facts, ostensibly a process server handed him papers, asked him who his name was, said, "You're being sued."
Well, I understand that as lawyers and judges, we're very familiar, but just to take the devil's advocate for a minute, the fact that he had just been talking to his lender within a matter of days, and now he receives this package that has to do with his mortgage. Can you kind of see how maybe he thought, oh, okay, this is the thing I was just talking to the lender about, and now it's here.
Which would beg the follow-up. If he believed that, and let's assume he did, the next step would be to begin filling out a loss mitigation package or the paperwork. If he was expecting that, I would expect he would have looked down.
Now, at some point he did that. It's a little bit unclear from the record exactly when that was submitted.
And that's the thing, Your Honor. We don't know, based on the affidavit, exactly when, outside of when he was mailed an eviction notice in July 26th of 2019. That, according to the affidavit, is the first time he became aware of this lawsuit, despite being personally served with papers that he thought was one document and turned out to be a court summons. So,
and at that point is when he called Mr. Torrens and realized, uh-oh, I'm in the middle of a lawsuit. I might lose my house. This isn't what I thought it was.
per the affidavit, yes. And that's, again, despite being mailed notices of hearing for a final summary judgment.
There was no counter affidavit. So do we have to take everything in that affidavit as true for purposes of the judge's ruling?
Just because there's no counter affidavit, Your Honor, doesn't mean that the affidavit submitted by the appellee isn't subject to scrutiny. If the affidavit contains statements which are, you just can't reconcile them, or if they're nonsensical, you don't have to just take everything as true. I mean, you could submit an unopposed affidavit that says, I was served by, little green men from Mars. And if I don't file a counter affidavit to that, it doesn't mean that the court automatically takes it as true. It's certainly subject to scrutiny. So the court can still look at that and say, something's not adding up here, even though there's nothing in opposition.
So this is my last interruption, then you can go forward with whatever you want to say. But apparently the judge found that there was excusable neglect, a meritorious defense, due diligence, and we are to assess whether or not that is a gross abuse of process.
Yes, and I understand
so
that
is the $1 million question. It seems like, given that he was working on this, was aware of the problem, hired an organization that he thought was helping him, and then hired a lawyer, is it a gross abuse of process for the judge to set this aside and say, okay, we'll give you another shot at it?
Exactly. And I understand that's an extremely steep hurdle to jump with a gross abuse of discretion. But given the totality of the circumstances of just how much notice this individual was on, service of process, every single document mailed, and then at the last moment, the 11th hour after being issued a certificate of title and being told you're going to be evicted from your home, only then do alarm bells start going off that a foreclosure action has been filed against you.
If I may, Mr. Nuri, let's just assume everything that you said, we take that. Wasn't there also in the record that at least Mr. Wiggs was under the impression that at least the company led him to believe that they were really acting on his behalf? There's a lot of emails going back and forth. So let's just assume, oh yes, it's a lawsuit. Let's just assume he should have known that. Let's assume all of that. If you add the added factor is that he was under the impression that they were taking care of it for him.
But then where's the evidence, Your Honor, of the follow-up, the email, the phone call to whatever company is working for him saying, hey, are you aware that there's a lawsuit? Or, hey, I got served with papers. Are you taking care of this? There's still just inaction on the defendant's part, even though he's working with this company. And one of the cases cited by my opposition, there's a similar fact pattern to that where a borrower was working with the plaintiff's attorney and was under the impression from the plaintiff's attorney that the bank had stopped foreclosure proceedings. And it turned out the bank hadn't stopped foreclosure proceedings, but there was due diligence on the part in that case because he followed up with the attorney. There was some sort of follow-up upon.
Yeah, and I understand that, I guess, and correct me if I'm wrong, at the hearing, I thought the representations were made to the court that even after receipt of the lawsuit, he was under the impression that they were basically acting on his behalf of communicating with the bank.
Well, and if that the representations made at hearing, Your Honor, I mean, those were unsworn, unverified, whatever was in the record as far as the transcript. The only thing we have that's sworn from the appellee himself is the affidavit. And based on the affidavit, I think it's hard to conclude that him expecting a loss mitigation package, getting served with papers, and then closing your eyes to it when you think it's a loss mitigation package, you would think that you'd go fill it out. And that'd be the first thing you do, or fill it out at some point.
And just so I can make sure I understand your position, because there's two issues here, we need to make a determination whether or not there is excusable neglect. And then the second prong is a meritorious defense. You do agree, at least as to that prong, he raised the
Due
issue.
diligence.
All right. So you're, at least with the meritorious defense, you're not disputing that prong of it.
Right. We're ceding that prong.
All right. So for purpose of our analysis, with the standard that Judge Black has indicated, that we're dealing with an abuse of discretion standard, the question for us to determine is there, based on this record, does it rise to excusable neglect, or as I'm hearing your argument that, any reasonable person would have known that this is not a loss mitigation package, and he was obligated at least to proceed and do something or to question something. Is that accurate to your position?
That's precisely my argument, Your Honor, is that the gross abuse of discretion here occurred because no reasonable person under these facts and circumstances would look at the affidavit and take it at its face value that I was expecting a loss mitigation package, and when I got served with court papers, I just kind of ignored it, even though I was expecting something to fill out. It just falls apart there, Your Honor. There's no.
It's interesting, Mr. Tony, because at the very end of the hearing, the court made a comment to counsel, for the appellant, said, well, the VA is the one that ultimately got it. So there's no harm nor foul. All that's expended is just the litigation cost. And here's this person, this is his homestead. How do you reconcile? And it is foreclosure. Foreclosure have been deemed to be equitable proceedings. How do you respond to that?
Well, Your Honor, equity still gives way to the law. And the standard here isn't whether or not, it's a big bank, they can just afford to do another foreclosure proceeding or go back to prejudgment. And I feel sympathetic. As a matter of fact, there's ample law that says sympathies for the borrower are not to be something that's considered by the court. So, Your Honor, there has to be some sort of assurance to the litigants that their final judgment is going to stick. And in a case like this, where I believe the bank did everything right and did everything within their power to give this defendant proper notice, and by the defendant or the appellee's own admission, received that notice and then did nothing with it afterwards until nearly a year later, when we have an emergency motion to vacate after the certificate of title has been issued. I think that's the line you finally draw of excusable neglect of, we're willing to bend the rule so much until, I think in this instance, you break it. And so that, I believe the basis here is that excusable neglect factor of, I got served with a foreclosure complaint. For whatever reason, I thought it was a different document, but still sat on it. And as far as the due diligence aspect, even after this occurred, even after all these chains of events happened, after all the notice, taking the timeline most beneficial for the appellee, we still have him saying in the affidavit, his first time getting notice was the letter of eviction dated July 26th of 2019. It was still until August of 27th of 2019 that a motion to vacate appeared on the docket. Most of the case law says a reasonable time after discovery of the default or the judgment. And most of the time, I would agree that even a month is reasonable. But under the facts and circumstances of this case, I don't think after everything that's happened, you can still wait a month after being on notice and say, now's the time to put a motion on the docket and get an attorney on this. I think that falls beyond what reasonable and what any objective analysis of the reasonable standard would be, to still wait a month when you've got an eviction notice on your door. So for those reasons, I think the court has to reverse either both on the excusable neglect prong and or the due diligence prong. And I'll go ahead and reserve the remainder of my time for rebuttal.
Your timing is perfect. You have your 5 minutes for rebuttal, sir. Okay, excellent. All right. Mr. Torrance, if you could proceed, sir.
Thank you. Good morning, Your Honors. My name is Ryan Torrens, and I represent appellee Terrence Wiggs in this appeal.
Mr.
Your Honor,
Torrance, can I just ask you one question? The question that I asked Mr. Noriega, because I read the transcript, in reading the transcript, the court seemed to be persuaded by the fact that the statement that were made that your client thought he was getting basically legal representation, that the company led him to believe that they were acting on his behalf. How do you respond to Mr. Noriega that specific argument was not set forth in the affidavit of your client and really should not be considered by us because it was just simply argument by counsel?
Yes, Your Honor. So I would respond by stating that in the appendix is a letter that was actually attached to the affidavit. And that letter is a cease and desist letter that was provided by Legacy Preparation to the servicer and with a copy being sent to Mr. Wiggs. And it actually says that we will be representing Mr. Wiggs as legal counsel. And obviously, there was no attorney involvement in this matter because none of the appropriate pleadings were filed, and that was attached to the affidavit. I was quite surprised to see that language. And so what that letter states is it's not just limited to the loss mitigation, but they actually said they were representing him with respect to legal counsel. Now, as to the commentary of the judge when the judge was about to rule at the end of the transcript, I think what Judge Stoddard there was doing is what a good trial judge is supposed to do, particularly in a court of equity. And Judge Stoddard noted at the end that these loans are foreclosed in equity. And he's saying, if it was any other loan, it's a VA loan, it went back to the bank, it didn't go to a third-party investor here. Even in the case of a modification, the lender can most likely be made whole in this situation. And you can see I'm kind of balancing the equities here and then finding that with it being a VA loan, that Mr. Wiggs could lose that home loan guarantee, which is a very harsh consequence. And so I certainly don't think that the appellant can meet the standard of showing that no reasonable person would reach the same conclusion here and finding that the equities did tilt somewhat in favor of Mr. Wiggs.
Would your argument change because in this scenario, we actually had a sale of the property?
Your Honor, I don't know that the end result should change. I think that it would have been more complicated because I understand the rulings of this court and other courts that a third-party purchaser does have a cognizable legal interest. And so I think at a minimum, it throws a wrench into it. That third-party purchaser may appear at the hearing with counsel and challenge arguments that we're making and make a demand for money or whatever. So I think that complicates it, but I don't think that the end result would be any different under cases going back to Heron versus Sunday, for example, which was not briefed in this case, but just that a sale based on a reverse judgment is not a valid sale. But I understand that sometimes the court's called upon to reconcile that with the legal interest of a third-party purchaser here, Your Honor. So moving on. So here we have a case where it is in the record that Mr. Wiggs served this country. He is a disabled combat veteran. It is in the transcript. Your Honors can see that he has suffered some mental health issues as a result of his combat experience. In the emails that are attached, Your Honors, to the affidavit, Your Honors could see Mr. Wiggs' many emails back and forth with the people at Legacy Preparation. And they're asking for more documents, and he's sending more documents, and they need clarification on some things, and he's providing that. And this is months before he was ever actually served with a lawsuit. And so he acknowledged that he was behind on the mortgage. We can see that in one of the letters, the hardship letter that was attached to the affidavit. And he's trying to resolve this unfortunate situation that has transpired before he was ever even served. And like Judge Black mentioned, $3,600 for an individual like Mr. Wiggs, that's not easy. And he came up with it because he knew he needed to take action to try to save his home. Your Honors, I would also point out as to due diligence, I would submit that Mr. Wiggs was working with due diligence by hiring Legacy Preparation, paying them the money, working with them, communicating with the lender, trying to resolve the situation, and then when he finally realizes that it looks like I actually am in court, it looks like I actually am being sued, legacy preparation doesn't seem to be doing the right things, then has to pay more money to hire our office to defend himself. And we filed the motion in a matter of days from the time that he had contacted our office, I believe within 5 days. And so I think that looking at the totality of the circumstances here and weighing the equities, I think that Judge Stoddard was certainly within his right to find that he acted with due diligence. Now, as to excusable neglect, I certainly understand the holdings of the Florida appellate courts that ignorance of the law is generally not going to be an excuse. But I think when we look at the totality of the circumstances here, and it is in the record that Mr. Wiggs had made that phone call earlier in the week to the servicer, it was later in the week that he was provided with these documents. In the middle of all that, he's working with legacy preparation on all of this. I would also cite to the Elliott case, which was mentioned in our brief, and it's not from this court, it's from the 4th District, but that was a case where you had some pro se folks who had a reasonable misunderstanding about the status of settlement and the settlement discussions. They were defaulted, and there the court found that the default was not appropriate in that case because there was a reasonable misunderstanding as to settlement. And so I would argue here, Mr. Wiggs paying legacy preparation to help him, legacy preparation going back and forth many times with him having what I guess we could call a reasonable misunderstanding that they were taking care of all of this for him. I think particularly in light of holdings such as Elliott and with a pro se homeowner who is a combat veteran who does have some mental health issues, I think when we look at the totality of all of those circumstances, that Judge Stoddard was correct in finding that Mr. Wiggs had demonstrated excusable neglect here. And as to meritorious defense, I know that counsel for appellant has conceded on that point. This is a VA loan requiring certain conditions precedent to be satisfied. And I think just as to the issue of the evidentiary hearing, it was mentioned, I think, in one sentence at the very end of appellant's brief in this case. Judge Stoddard at one point actually asked counsel for appellant, is an evidentiary hearing going to be required? And counsel responded by saying that he didn't believe one was going to be needed. And so I think any argument about an evidentiary hearing has been waived by asserting that and requesting it for the first time on appeal. With that said, I would actually conclude my argument by just referring the court to the very end of the transcript where you see Judge Stoddard weighing the equities here. And I think the way he ended it really says it all, where he says, we have a disabled veteran here. We have a VA loan here. The property is held by the bank. This is a court of equity. This man is trying to save his home. And the court thinks that it's no harm, no foul to give this man that chance. And if it doesn't work out, the appellant still has its opportunity to go forward with the case. The appellant still has the opportunity to try to recover any additional amounts in attorney's fees that have transpired because of this litigation. And so I think the appellant cannot meet the standard today of showing that it was a gross abuse of discretion and that no reasonable person would have ruled the exact same way that Judge Stoddard ruled in this case. So absent any further questions from your honors, that would conclude my argument. And I would respectfully request that your honors affirm the order below.
Very good. Thank you, Mr. Torrance. I don't believe my colleagues have any questions. All right. Mr. Noriega, you do have your full 5 minutes, sir. And Mr. Torrance, can I trouble you to mute your microphone?
Thank you, Judge.
Thank you, sir.
Yes, several points to address. The beginning with the documents attached to the affidavit, notwithstanding that those weren't in any sort of evidence or authenticated, the specific letter that was referenced is an undated letter, the cease and desist letter. So we don't know if that was sent out to the servicer, Doven Mule, after the complaint was served or before, when the appellee retained legacy preparation. We simply don't know. The only thing that indicates on the letter as far as the date goes is as of March 5th, 2018, Terrence W. Wiggs has retained legacy. And March 5th was pre-foreclosure. So I don't think you can use that as evidence that, the appellee was relying in response to the complaint on legacy preparation to handle things. Now, counsel makes a good point with the emails of months of correspondence going back with legacy. The thing that's missing from those emails, despite all the communication, was not once the appellee saying, I got served with a complaint. Do you know anything about this? Or any sort of follow-up or questioning as to, hey, final judgment's been entered. I got served with a notice of default, etc. The emails are completely silent as to that. So again, it's one step that would have changed the outcome, I think, or at least the fact that this was a defensible ruling was there any sort of follow-up, any sort of communication in the record whatsoever after being served with a complaint, after notices being sent, or anything just within the record of inquiry as to these documents, which brings me to the Elliott case. Again, the most distinguishing part of that case was the misunderstanding. After the appellant was served with the complaint, he contacted the plaintiff's attorney to ask about the loss mitigation process. And then after contacting the plaintiff's attorney referred that borrower to the bank and said, yeah, you guys can work something out probably, even though the foreclosure kept going. And that was the basis of that party's excusable neglect and misunderstanding, was that he contacted the plaintiff's attorney after being served to see what was going on, versus here, there's simply no action being taken. As far as the issue of waiver of an evidentiary hearing, that issue simply isn't before the appellate court. There's been no mention within the briefing as to waiver, so I don't believe the appellate court can consider that in the argument. And finally, the argument of equity. The thing with equity is it goes both ways. The bank, I know it's a big bad bank, but it gave the borrower his day in court. Service of the process was delivered. Every single notice went out afterwards. And to say, well, it's no big deal now for the plaintiff to go back and get a judgment. That's not true, because now there's, defenses. This isn't simply just going back to court next week and having a 5-minute hearing. If this is going to be litigated, which the defenses have certainly put it in a posture to be litigated, it's a completely different lawsuit. So, the equity, I believe, goes both ways. And, you can't use that as both a sword and a shield just because one of the parties might be more sympathetic than the other. And if the court has no further questions, I think that concludes my argument.
Very good. Thank you, Mr. Noriega, and thank you, Mr. Torrance. Really well argued on both sides. Thank you both.
Thank you.
All right. So our next cases that I'll be calling is the case of Andrew Kada versus Mayada Kada. And I believe we have attorneys Burlington